May it please the court, I'm Gary Mankowski. I represent the appellants in this case, Mandeep and Saran. This case involves a alleged breach of a commercial listing contract between Cutler Real Estate Company and Mandeep Saran. The commercial listing contract was executed on April 25th, 2008. There was a time period for the contract that was in effect from April 25th, 2008 through November 30th, 2008, plus a 180-day protection period if the real estate company had brought any prospective tenants or prospective buyers. If they sold to that party within 180 days, they would have to pay a commission under the terms of the commercial listing contract. Jack Cutler, who was the agent for Cutler Real Estate, who was assigned to this job, had an extensive history with the Sarans. Multiple properties had been purchased and sold in the past, and he had been paid commission for those prior purchases and sales. He procured a tenant by the name of George Albana, and the lease was executed with Albana on or about July 1st, 2008. The lease period was from August 1st, 2008 to March 31st, 2009, and there was a one-year option renewal period. The commission was paid to Cutler Real Estate by the Sarans in July of 2008 based on the 1 year lease that was executed. No further commissions were paid. There was a renewal of the contract on July 29th, 2009.
The rental contract.
Of the rental contract, yes. The document was called the Lease of Commercial Building Lease Renewal. That was done by Mr. Saran himself and Mr. Albana. There was no input from the realtor company at that point in time. It was a 1 year renewal with a 3-year option period for Mr. Albana. There was a subsequent lease on September 1st, 2013. Again, it was designated a lease of commercial building. That was attached to Mr. Saran's affidavit as an Exhibit A, and that was from September 1st, 2013 through August 31st, 2015. Again, there was no involvement on the part of Mr. Jack, I can't remember his last name now. Marcello, thank you, or Cutler Real Estate. In the meantime, on October 16, 2014, there was a sale of the property to Unsurpassed Holdings, LLC by Mandeep Saran for the sum of $270,000. Again, there was no involvement on the part of Jack Marcello or Cutler Real Estate. No real estate commission was paid.
Was that thing within the extension period?
Not within the original extension period, but within the extension period of a contract that was executed on September 1st, 2013 by Mandeep Saran and George Albana. Again, there was no involvement by Cutler Real Estate at that point in time. After the initial lease, there was no... Well, there was testimony that from Mr. and Mrs. Saran that after the initial lease was executed between George Albana and Mrs. Saran back in July of 2008, there was no further contact with Mr. Marcello regarding his property. He wasn't involved in the lease renewals. He wasn't involved in a contract for the sale of the property. They did all of that on their own with Mr. Albana and subsequently Unsurpassed Holding LLC. Admittedly, Mr. Albana was a partner of Unlimited Holdings LLC. So the
was that LLC in existence at the time? Was that who signed the original lease?
No, the original lease was signed by George Albana individually,
But not
the LLC. No. Suit was brought then on February 3rd, 2015. Of course, the plaintiff in this case filed a motion for summary judgment, and the court ruled in favor of Cutler Real Estate and awarded judgment for $26,000. We filed an appeal. Our position is, I think the Karen case is really an important case. Obviously, it's a Ninth Judicial Court of Appeals decision from Ohio, and it's a similar case. And in that case, the court held that there was no commission due under a listing agreement because the contract that was entered into between the, let's see, in that case, the owner of the property was Ellis and Claire Miller, and they had leased the property to Claire Miller. The owners were Ellis, Mitchell and Mary Ellis, and the tenant was Claire Miller. She ended up becoming engaged to a William Ellis, who was, I think, the brother-in-law of one of the Ellises. And ultimately, Mr. William Ellis purchased the property, but some of the funds that were sold when Claire Miller sold her previous house were used to purchase the property. And ultimately, William Ellis had quitclaimed the property, or not quitclaimed, but brought her onto the title. Apparently, there was a subsequent title where he transferred his interest to himself and to Claire Miller. The court.
I'm a little confused about the dates of all these transfers. Was the sale of the house within the extension period?
Are we talking about the Karen case or the present case?
This case?
In our case, the transfer of the property, the sale of the property was October 16, 2014. What the last agreement that was entered into between Mandeep, Saran, and George Albana was executed on September 1st, 2013, and the term of that lease agreement was from September 1st, 2013 through August 31st, 2015. Therefore, the property was sold within that lease period, the last lease that was executed.
Well, the agency, there was an extension period, correct? For which any transfer of the property during the extension period would result in the commission back to the agency.
That's correct.
And my question was that sale, for which the $26,000 was owed, within the extension period?
It wasn't within the one-year extension period. Cutler had procured a lease for my clients back in July of 2008, which was a one-year period from August 1st, 2008 through July 31st, 2009, with a one-year option to renew the lease. That was the contract that Cutler had procured for my clients. Obviously, by the time that extension period had expired, we were several years down the road when the property was sold. And I asked Mr. Marsola when I took his deposition if this lease went on for a period of, let's say, 50 years. Is it your position you're entitled to a commission, and you're entitled to a commission not only for the lease of the property during the 50 years, even though you have no involvement, and the property subsequently sold 50 years later, is it still your position you're entitled to a commission? He said yes. So I think it's absurd to think that because they procured an individual to lease a property for a one-year period, at max it's a two-year period, that they would be entitled to commissions forever on this property when there was no further involvement. That's the testimony of my clients. Once the original contract had expired and the the one-year option period had expired, there was no more involvement by Mr. Marsola or Cutler Real Estate, yet they believe that they're entitled to a commission during that time period because they procured a ready, willing, and able buyer. Well, the buyer, although technically isn't the same party, there's a distinction because we have an individual that executed the lease originally, George Albana, and he signs as a partner for Unlimited Holdings, Unsurpassed Holdings LLC, 5 years later to purchase the property. Our position is that the Karam case kind of hits the nail on the head, because the finding of this court in the Karam case was that the realtor in that particular case wasn't entitled to a commission on the contract because the sale did not occur during the terms of the listing agreement. And the way that the court found against the plaintiff in the Karam case was that the realtor stayed involved in that particular case, and the realtor prepared subsequent leases that made a provision in the lease that said that the realty company would be entitled to a commission still. So that's the big distinction between this case and the Karam case. Once the one-year contract was executed by Cutler Real Estate, or procured by Cutler Real Estate, according to my clients, there was no further involvement by Mr. Marsola or anyone from Cutler Real Estate as far as further transactions with Albana or Unsurpassed Holdings LLC. In the
Counsel, you have 4 minutes left.
Thank you.
Statement.
In the Karam case, it's just the opposite. Even though the original lease period had expired, the realtor stayed involved in the particular transactions and had even procured a further lease wherein the lease itself had indicated that the realty company would be entitled to a commission. So the basis of the Karam case is that the commission is based on a subsequent lease which specifically provided for commission being paid to the realtor. It wasn't based on the fact that they were entitled to a commission under the original listing agreement, because that listing agreement had expired. Just as the listing agreement in this case has expired, our position is that the plaintiff, Cutler Real Estate Company, is not entitled to a commission because that listing period had far expired. There was no further involvement by Jack Marsola or anyone from Cutler Real Estate.
There certainly wouldn't be any incentive for your client to continue on with this particular tenant, knowing that in perpetuity he's going to keep paying finder's fees to the...
And that's basically what this boils down to. They're claiming that they're entitled to a commission based on a one-time find of, they were able to secure, as far as you can extend it because of a one-year option, a tenant for a 2-year period. And at best, that's all that our position is that the Cutler Real Estate Company should be entitled to, would be a commission for the second year when the option was renewed. Now, Cutler Real Estate never bothered to send any invoice to our client during that time period. Jack Marcello indicated in his deposition he was aware that there was an extension, and he was aware that the tenant still had occupied the premises there. They never billed them after the initial billing for the first year lease. But once the property was sold, then all of a sudden they sent a bill for $26,000 saying, well, not only do you owe us for the period that you leased the property to Mr. Albana for approximately 5 years, but you also owe us for a real estate commission for the sale of the property. Unless there are any questions, I'll reserve my 5 minutes.
Thank you.
Thank you.
Well, you have a minute and a half now.
All right, thank you.
Thank you.
Good morning, my name is Jim Conlon, I represent Cutler Real Estate. Let me address a few points that are raised in counsel's argument that I think are black and white. They're not really open for debate, but the case law is clear. First, Karam does not say what counsel said. Karam actually awarded a commission. So his reading that they did it is incorrect. Karam awarded a commission. There's only one case cited in the appellant's brief, and that is a paragraph in Karam. And it says, although Miller was procured through Karam's efforts, she did not buy the house during a listing period. According, no real estate commission could be due under the terms of the agreement. That's what he cited. He didn't cite the next paragraph, which is very important because it actually mirrors this case. The next paragraph says, however, a lease with an option to buy, which they entered into, which was during the listing period, gave the right for Karam to be paid a commission, and that was the party's intent. In other words, there was a question Judge Whitmore asked if the agreement or the purchase happened during the listing agreement or the extension. 'Cause. I represent Cutler all the time, so I've dealt with these cases a few times. That's not the important thing for purpose of law. The purpose of a real estate agent is to procure a tenant, either to enter into an agreement for a lease or some sort of transfer to buy. The job of a realtor is to bring that person to the seller. If it was a matter of entering an agreement during a listing period, guess what everyone would do? They would let the listing period expire and enter an agreement the next day. Of course they would, that's how you save the commission. Once Cutler brings someone to the buyer and they enter an agreement to lease or transfer it, they've done their job. What Karen said is very important. What they said is, we will award a commission, contrary to counsel said, if you look at the next paragraph, because when the parties enter into a lease with an option to buy, it showed an intent that there was a purchase thought between the parties. And the purchase actually happened, so they awarded a commission to the realtor in Karen.
What if the purchase didn't happen for 10 years?
Never addressed in Karen, not addressed in our case. That was the intent of the parties, that because the realtor brought them this person who entered into a lease, continuously held it, and eventually purchased it, but for the action of a realtor, they wouldn't have had that person buy the property.
How do you explain the fact that it's not the same person?
It is the same person.
Well, it's not, now it's an LLC where it was an individual.
The sole member is in evidence in the trial court, says a sole member LLC with George Albana. Same thing. He can, once again, that would be clearly, if that were the only way around it, everyone would do that. George Albana is unsurpassed holdings, that's in the record. So if he forms an LLC, it doesn't change the fact that but for Cutler, George Albana would not have been there to purchase the property.
I may have the facts confused, but a commission was to be paid on the lease, correct?
That is not true.
That is not true.
That is not actually true. A commission is to be paid if the property is leased or transferred during the period of the listing agreement or the protection period, which is the period immediately after that. Now, what Karam says, and what Ohio case law says, if that person you lease to eventually buys it, and there's an intent in the lease, in our case, there's a right of first refusal, so there's an intent to purchase it, just like Karam, that a commission is awardable in those circumstances. In Karam, a lease was entered into during the listing agreement period or the protection period. They leased it, and there's an option of purchase. The court said, you intended to purchase it, so a real estate commission should be paid. In our case, the lease had a right of first refusal. The court doesn't care whether the right of first refusal or option of purchase is technically followed. The intent is there. So the same situation occurs. It is confusing, but the intent is, once again, why do we have a listing agreement? So the realtor, during their term, if they procure someone who enters into an agreement for a lease, transfer, sale, that the intent is they get paid a commission. The protection period, so if the parties say, hey, let's wait till this listing agreement ends, the day after we'll enter into it, it gives the realtor some protection. It's undisputed the lease was entered into during the listing agreement, just like in Kira. It's undisputed in both cases there was a right of first refusal or an option of purchase, an intent to purchase it, and that the same parties procured by realtors in each case made that it happen because of their efforts to bring the buyer. In Karam, the commission was paid. The same thing should happen here.
But isn't a right of first refusal a little bit different than an intent to purchase, than a purchase option?
I mean, with all due respect, personally, I don't see it though, because once again, the parties are contemplating, hey, if someone else goes to buy it, I want the right to buy it. Same thought in mind that, this person leasing it, if they didn't care about buying it, there'd be no reason to have that in there. Hey, if you guys sell that, I want to make sure that I have the right to get that. If not, that's all right, but that's the intent. And once again, but for Jack Marcello's actions, there would never been George Albana there. Let me address a few other things.
When you say things like that, that does sound like Judge Schaefer saying like a finder's fee.
That's how real estate is procuring buyers for a seller. That's it.
I
don't know
understand that.
I don't know
I
this.
guess what I'm saying is, I'm just not sure, and I'm sorry, Judge Schaefer, let me ask this and I'll get to you. I guess I'm just not sure how far that extends out, because the question was presented by Judge Schaefer and Judge Whitmore. And you said that's not addressed by this court.
It never has been, too.
Well, but we're gonna have to address it maybe at some point, if not in this case, in another case. How far does that go out? And I think Judge Schaefer mentioned to you, what if it's 50 years?
You're right. I don't have the answer to that, but there's a few things I can tell you that's not. Counsel argues it should be a year in, that's just arbitrary. There's no why. The parties just end the lease and start a new one just to get around it. Once again, there's an intent here that Why should they unilaterally be able to say, hey, we brought you this person, they bought it a few years later? 50 years, legitimate question, but here we have 6 years later.
Okay, well, let me ask you a question. Hypothetically, you said that this guy's only there because of Cutler and Marshall.
Correct.
He's only there.
Undisputed.
Okay.
Yeah.
So hypothetically, during that year and a half, say the Sarans turn out to be really crappy landlords.
Yes.
Are you gonna sue them because they were crappy and you lost out on the commission you could have gotten because they were crappy landlords?
Nope, that's not what the agreement says. It says that we
But
get,
it could have, I mean, that would be breaching a contract, right?
but it didn't say that. It said we get 6% of any monies realized through our efforts. So it doesn't say that.
Doesn't it say just for the year and then the following year?
No, it does not say that at all. If this is a contract case, you keep arguing they had no involvement. There's no requirement we have involvement. That's not the contract. So you can't just, this is contract law. It's not a matter of, well, Mr. Saran doesn't believe that we should be paid more than a year because we have no involvement in subsequent agreements. They're not lawyers. They don't draft agreements.
Just so I understand, for a certain period of time, they paid rent.
I think they paid rent for a number of years. We got a commission, I think, the first or second year.
Right, and then later on, and I don't know how long later on, it was sold.
In 14, I believe, I think 08 was the original
Is
lease.
that still within the time period?
No, and it wouldn't be, because you have a 6-month lease agreement, I think the protection period is 6
Okay,
months or a year.
So they get the commission on the rents,
Correct.
and then for an indefinite period of time, when the house sells,
Not indefinite, as long as the tenants are there and or if it's purchased by this person. If they would have,
Okay.
if people moved out, we wouldn't got any more commissions because they're not getting rent from the person we procured them. So it's definitive, at least, I mean, with all due respect, if the person passes away or no, that ends. So it is a definitive, it's as long as they reside there and or if they purchase there. That's what the parties, the contract's unambiguous, there's no ambiguity being argued on this appeal. So the problem is, our feelings say, I understand your concern. Well, that's going to go on forever. But we're looking at the contract for what it says, the things. It's undisputed that the lease was entered into during the listing or the extension period. So we procured a buyer during that period, in that Mr. Albana stayed during the entire period until he purchased it. In that there is a right of first refusal, intent to possibly purchase in the agreement. Karam says the same thing. The facts of Karam awarded the commission when you had a right to purchase in the lease, the person stayed there and eventually purchased it. They said, hey, there's an intent to pay the realtor for their efforts because you procured a buyer.
they took a portion of the rentals,
Correct.
and was that based on a percentage?
6%, I believe, that is in the listing agreement.
Or
Correct.
if there had been no sale, would they have been entitled to the percentage for the next 12 months of the lease and the next 12 months of
Yes.
the lease and ad nauseum until the property was vacated?
Until they left or passed away, correct, yes. If he just left, if he instead of buying and saying, no, I don't want this place anymore, our right would end. Because when we put these folks together, any amount realized, right? Usually, the problem is a different transaction. Usually, when we've all bought houses, you buy it, the sale happens. If you enter into an agreement, whenever sale happens, it doesn't matter. The agreement to purchase was entered into the agreement. That sits well with us, because, okay, that's clear. The problem is, let's think of a situation where people say, okay, a good way to get around this is, if we lease it for a while, then we purchase it, this lease for 5 years, we'll enter 1-year agreements. There's the other side of it, that's the problem. That's happened a few times for various realty organizations around town where, I'm not saying that this is the case here, but if I sell to someone saying, look, let's enter in a year agreement or two, you can buy it for 5 years, I'll just take it off the price at the back end. Well, that's a great way around paying a commission. You don't got to pay a commission now.
Wouldn't you get your 6% during every year of the lease?
Correct, that's what it was.
Kind of like a double whammy, isn't it?
Well, you get 6% of the lease price, and then ultimately they agree on it, you get 6%, so I don't
Sale
know.
price.
Yeah, because you got to lease it for all those years, and they got to sell it, so they also got twice, so we would get it.
Well, I think Judge Schaefer's just saying that, that you weren't heard in the respect that you were getting the lease proceeds as well. But now he's saying that you didn't, you, Cutler.
Yeah, I understand.
And didn't even ask for the lease proceeds until after the sale.
There's no, we don't have to bill them every year, I think it's not in the record, but I believe, actually it might be some deposition transcripts, I think they're just trying to do this guy, there's no reason to bill him, we'll pay when he sells it, all some more money. I don't know if that
But
really,
it may not have sold for, again, 50 years.
it might not have, there's no,
And then you guys would have foregone your 6% for 50 years?
my guess is,
Well, they
my
have
son or
a lot of
son would
property.
be sitting here talking about
I'm
that.
sorry.
In the end, you end up owning the property after 50 years, because certainly, I mean, hypothetically, the property isn't gonna be worth what the cumulative amount of lease would have been, so you would have just assumed ownership of the property at some point,
I don't know about that, I guess I always go back to
hypothetically.
the problem becomes is, the appeal filed in this case does not argue ambiguity of that aspect of it, so I don't know if it's improper. Your heart, I have concern for what your heart is, but the way this appeal is brought is not really address that. You have to argue ambiguity in the
Well, keep in mind,
contract.
just because we ask you questions doesn't mean we're leaning any particular
I
way.
understand
We're a lot of
that.
times just trying to figure it
Yeah.
out, so don't read too much into that.
There's
I'm
no-
just saying for both sides, just, when we give appellate seminars, we tell people that. Sometimes we ask questions just for each other, sometimes we want clarification, sometimes we're playing devil's advocate, sometimes I play dumb, and sometimes I just am dumb. So,
I fully understand that, and I think,
you fully understand that? No, go ahead.
no, I do, there's a certain aspect though that you can draft a provision a certain way, is, I don't know, the problem is, this is not, the intent is not to play games with anyone, but the problem becomes is there are unscrupulous people out there that if you say, this looks like a year or two, every realtor's been through it where you bring someone in and then the two people get together to cut out a large commission. I'm not saying it happens here, but that's the problem on the other side of it.
And we understand that, the thing is with the appellate court, and I understand the attorneys realize this, but I like to say it for maybe the audience, and just as a reminder even for the attorneys, and we do webcast these, that we're not just deciding this case, we're making the law for the district on this issue. And that's why we like to ask hypotheticals and so forth. How far does this extend out? And I understand your point. We're talking about a specific contract here, and that's well taken.
It's an area of the law in an aspect of it with realtor commissions that is always struggle with various, it goes, not to get off topic, but it's almost like the recent FLSA issues where our realtors employees and, the realty companies have to control them because they are named with them, but they're also independent contractors. Unfortunately, I think that this area is kind of just fraught with that. How many more minutes do I have here on? I didn't keep track of my time.
We have about a minute and a half.
Let me make sure there's no points that one thing I think is important, I think might be misunderstood generally, and I'm not speaking for this court, is some struggle with the fact that the listing agreement and protection period, I think a common error is that the parties don't purchase it or exchange it during that period is not under that. And that's, I think I've said it, but let me just be clear. The idea is that the person is identified during the period or protection period, and at some point they enter into agreement to transfer, sale, or lease is covered under the commission agreement. If it wasn't that way, and it was made it had occurred during the listing agreement or the protection period, everyone's just gonna wait till the day after. So that's a fine distinction, I think. I think it was briefed well at the trial court level, but I just wanna make sure we're clear on that. Once again, to summarize here, not to beat a dead horse, although I might be guilty of that already, but for the fact, it's undisputed that Cutler actions led to this lessee and purchaser, Mr. App.No would not have had a lease for 6 years and sold the property for $270,000. But Cutler won on summary judgment a right to the commissions for their efforts, and we would ask that you affirm the trial court's grant of summary judgment. Thank you very much.
Thank you.
Appreciate it.
Thank you. And you have about a minute and a half.
I will just return to the Karam case because it was quoted by myself and by counsel. The language is, during the continuance of the lease, denominated as Plaintiff's Exhibit 4, it was the intent of the parties to pay a commission to the plaintiff when the property was sold, admittedly through their efforts. Again, in the Karam case, the realtor stayed involved, drafted the agreement, the subsequent lease agreement, and made a provision in that agreement for there to be a commission paid. So it wasn't the listing agreement in the Karam case where the court awarded a commission to the realty company. It was the subsequent lease where the listing company stayed involved and prepared the contract and made sure that they got paid a lease. In this case, what Cutler Real Estate did is they secured a lease for 1 year with an option for a second year. At best, they are entitled to a commission for 2 years, because after that, they're completely out of this case. Their control or their input had no further impact on these parties. The parties drafted their own leases afterwards. Cutler wasn't involved. Cutler never billed them. I don't think Cutler intended to be paid by them. But when they discovered the sale, all of a sudden, they say, we, not only do you owe us for a commission, but you owe us for the last 4 years as well. So if the court decides in the favor of Cutler on this one, you're going to be faced with an issue sometime down the road where somebody's going to come in here for a very lengthy period of time on a lease and say they're entitled to a commission 10 years later, 20 years later, 30 years later. And that's going to happen someday, probably.
And counsel, you're out of time.
Thank you, Your Honor.
Thank you. Thank you both for your presentations to the court. The court will take the matter under advisement. We'll issue a written opinion, and also we'll put it on our website. So
Thank you.
appreciate
Thank
your
you.
time, and please have a good day.